When the dust settles here, our client has sold this block of Nvidia stock or has sold the business that they worked so hard to build. They've ultimately sold it for cash, but how are they reporting the capital gain on that cash?
On the installment treatment over the 20 years of that promissory note.
It sounds too good to be true, and in some cases it is.
It's a powerful tool. Section 453 can be a huge benefit in the right situation.
Good morning, everybody. I'm Matt Dana, coming to you from sunny Scottsdale, Arizona with Dana Whiting Law, and I'm here with my partner, Mr. Trevor Whiting.
Hey, Matt, how you doing?
And you know what's going to happen when Trevor's around, right?
We're going to talk taxes.
Maybe say a few code sections, little regulations.
Get a little bit excited, get those tax nerd juices flowing.
If they start flowing, we know it's a great discussion.
That's right.
Trevor, we're going to talk about a topic today that's quite different than most of our topics. Usually we talk about the estate tax and the gift tax and then the generation skipping tax, and we talk about transferring wealth from generation 1 to generation 2. Today we're going to shift gears and talk about capital gains. And we're going to talk about the client that might have a big block of maybe Nvidia stock. They might have a big asset in thinking about selling their business. They're having something that's a capital asset that they know they're going to sell in the future. And Trevor, what normally happens without any planning? Let's say let's make up a hypothetical. A client's got, I'll say, $10 million of Nvidia stock. They want to diversify that stock. They know they need to sell it. What would normally happen when they sell that Nvidia stock?
Yeah, so when we're talking about selling an asset, we always need to be concerned about capital gains. And so when they're selling the asset, they have to figure out what did they pay for it, and then they're going to pay capital gains tax on the difference between what they paid for it and what they actually sell it for. And that's the capital gain, and they'll pay a tax at on a federal level, probably between 15 to 20% rate or so. And so that's when you're selling that capital asset, you got to be worried about that.
Yeah, and when you talk about that, what they paid for, I think we call that a basis, right, or a cost base. And so very, very well said. And a lot of times people are really nervous about diversifying because they don't want to pay this capital gains up front. And Trevor, I've always thought it's interesting that if the capital asset they're selling is a piece of real estate, they have a lot of options to defer capital gains. They can do a Code Section 1031. They can defer the capital gains into a new piece of property. Tell me how an installment works on a piece of real estate. Let's say, I own this building here. I decide I'm going to sell this building to you. I'm going to sell it to you for $2 million. If you pay me cash, I pay capital gains up front. I'm not liking that idea. How can I get a deferral of that capital gain using an installment note?
Yeah, so when a seller sells an asset using an installment note, meaning they're going to receive payments over time and the buyer is making those payments directly to the seller, then because the seller didn't get all of his money all up front, then the tax code is a little bit generous and says you only have to pay tax, this capital gains tax, as you receive those payments. And so we do a calculation, and each payment that's received, there's going to be a portion that's a return of your cost basis, and then a portion that's a part of your capital gain. And so we're going to prorate that payment, and you're only going to pay capital gains taxes on the piece that's a capital gain as you receive each payment. So if you have a 20-year note, you're deferring your taxes and you're paying those capital gains along the way as you receive payment, where you don't have to have the money all up front for those taxes.
I've always been jealous that real estate has these deferral opportunities that selling my Nvidia stock, I don't. I can't sell Nvidia stock on an installment basis. But I could sell it on an installment basis if I wrapped my Nvidia stock into an LLC, right?
Right.
And now could I sell that LLC on an installment basis?
Yeah, I think you could.
And then I could get that I could get that deferral, right?
Right.
All right, so let's talk about for a second this particular transaction I'm going to set up on how we can get deferral if I need to. I want to sell my business and I want to sell it for cash, but yet I want installment sale treatment. I want to use this promissory note. So set this up, Trevor, on this first slide we're taking a look at. It says client sells to a trust the first sale. So walk me through what's happening in this particular slide here.
Yeah.
And I think we're showing he's got a $10 million asset. Maybe it's his own company business. Maybe it's some Nvidia stock wrapped up inside of an LLC, but he's selling this capital asset for $10 million. Walk me through that.
Yeah, so what the client does here is they takes that capital asset and he sells it on an installment note to an irrevocable non-grantor trust. We've got lots of videos where we've talked about grantor trusts, but fewer videos where we've mentioned non-grantor trusts.
Yeah, a grantor trust means it's ignored for income tax purposes.
Right.
And we use that for estate tax planning, but here now that we're talking about capital gains, we want to actually trigger the capital gains tax. So this has got to be a non-grantor trust.
This is a non-grantor trust, which means that trust is a separate actual taxpayer. And so it's as if the seller is selling to a third party. From an income tax standpoint, they're selling to a third party, and that's where they can get that installment note treatment under Section 453 and take back payments and pay capital gains over time as they receive those payments.
Yeah, and so that trust, we're showing this is a green box. It's a non-grantor trust. It buys that capital asset for $10 million. It turns around and gives the seller a $10 million promissory note. According to this slide, there's going to be 20 years of quarterly payments, and each payment's going to be $191,000. And on that, Trevor, that $191,000 payment, a piece of that would be interest income, but a big chunk of that would be capital gains, and he's doing that, right?
Yeah, a piece of it would be interest income, so you have some ordinary income tax on that interest that they're collecting. And then the remainder of it is going to be split between a return of the seller's basis. So if they have basis in the asset, then it's going to be return of basis and capital gain. So they'll pay tax on the capital gain portion and on the ordinary income interest portion.
The key here, Trevor, is how do you set up this green box, this non-grantor trust? And we're not going to get too far in the weeds, but understand the taxpayer, our client, this is going to be a very friendly trust to this taxpayer, right?
Right.
That taxpayer is going to want the beneficiaries to be maybe his descendants, maybe his children, maybe his grandchildren. It's going to be a very friendly trust. And I'm using that term very delicate because there's some very complex rules. The IRS is very concerned whether this trust is what the IRS is going to call a related party or a non-related party. And that's where the regulations to Code Section 453 get very, very interesting on this. And, you know, you and I first kind of cut our teeth looking at 453 when we represented our clients that were Phoenix Suns owners. And when they sold out to Matt Ishbia a few years ago, you know, there was some opportunity to do some capital gain planning. And that's where we first got real involved with Code Section 453. And Code, 453 is a black and white code section. It says you do A, B, C, D, you get installment sale treatment. So the key on this is this trust a related party or a non-related party? But we'll get to that detail in a minute. But now let's go to the second transaction. So that trust bought that asset for $10 million. That trust now has basis for $10 million. So that trust turns around and what does it do, Trevor?
So now that irrevocable non-grantor trust that just bought that asset turns around and sells it to a third-party buyer.
For cash.
For cash. So that's the buyer that had the cash, was ready to go, but now they're paying the cash to the non-grantor trust. And because the non-grantor trust has basis because they just bought the asset, then there's not going to be significant capital gain on that second transaction.
Yeah, so you mean to tell me when the dust settles here, the client, our client, has sold this block of Nvidia stock or has sold the business that they worked so hard to build. They've ultimately sold it for cash, but how are they reporting the capital gain on that cash?
On the installment treatment over the 20 years of that promissory note.
It sounds too good to be true. And in some cases it is. There again, the key is this box a related party or a non-related party? And I think, Trevor, let's go back to slide 1 for just a second, Trevor. And this is on the first sale where our client sells to the green box, this very first sale. Generally speaking, the more that trust is kind of tailored for the client, the more it's his beneficiaries, his trustee, the more friendly party elements to that trust. Yeah, so this trust, if it's a related party, then what has to happen with it?
Then we have to wait 2 years in between that first sale on the installment note to the trust and the second sale to the third party for cash.
So this could be a related party in the sense that it's a friendly trustee, it's his beneficiaries. This was all part of a plan and a scheme to do this. The plan and scheme works very fine if you've got this 2-year period. Now, if it's a non-related party, then we don't have to wait the 2 years, right?
That's right.
But I think you still have a problem, don't you, Trevor, that on this first sale, what kind of problems do you see on this first sale if there's actually already a letter of intent for the second sale?
Yeah, there's concerns that, on each situation we'd analyze it separately, but there's concerns on a couple things where the IRS wants to challenge a transaction like this because, like you say, sometimes it does seem to be too good to be true, right? Then the IRS is going to be looking at, is this what they call a step transaction, where we have these independent steps, but it's all related to trying to come together with some specific tax result. Then they might unwind the different steps and just say, no, you just sold it for cash, right?
Yeah.
And then another one is maybe the assignment of income doctrine, where the IRS says you can't take an income tax liability that belongs to you.
You've already triggered the liability when you signed the letter of intent, or you've got this obligation to sell.
Right.
You're already obligated.
You're obligated for it. You can't now assign it to this irrevocable non-grantor trust and get out of that tax obligation by assigning it on that sale.
Yeah.
So there's a couple things that we are wary of, and we want to be very careful. And we work with our clients to to analyze those situations and see how we can customize this to fit their situation.
You can see a situation where where the IRS is really right on this, right? I mean, we try to talk about this being a non-related party, but really this second cell's already lined up. These are our friendly beneficiaries. You kind of see this whole step transaction doctrine. The argument is the client would not have done step 1 without knowing that step 2 is a certainty.
Right.
And there's where you collapse those 2 steps and you end up with the client really just sold it for cash, trying to get installment treatment.
And that's where the IRS is trying to get to with that 2-year period in between those 2 steps. That will discourage and eliminate some of those attempts to get that benefit.
Yeah, and I like the way you use the word discourage. I mean, still, if you want to do the sure thing, wait the 2 years, and then it's cut and dry. It works, and this can be a related party, and everything works fine. And you're only challenged in that 2-year period. You just got to come up with a mechanism where we're paying income tax on this money coming out before the business is actually sold. But you're going to have cash flow from the business that you could do that. So
yeah, it'll work really well in the right situation.
our caveat here, Trevor, this is a very complex code section with the regulations, and we saw that with the Phoenix Suns transaction. And you've got to be very careful because I think you and I know and believe there are different institutions out there that aren't lawyers that are promoting this strategy as though it's cut and dried, black and white. But if it's not done right, tell me, is this a strategy the IRS is onto? Are they're aware of this strategy?
They're aware and onto it, which is, I think, why they have the regulations that talk about the 2-year rule for a related party transaction. So it's definitely something that's on their mind and they're looking at, and they're going to be watching those types of transactions.
Yeah. What's your closing thoughts on this, Trevor, on this transaction?
Yeah, it's a powerful tool. Section 453 is code section. It's utilized very frequently, and to defer capital gains tax when you're receiving payments over time, and incorporating it with a irrevocable non-grantor trust can be a huge benefit in the right situation.
Yeah, and just to close out the video, there's other videos we have out there where you can get some capital gain treatment on selling a stock position or your business. We've talked about our charitable remainder uni trust is a way you can get capital gain deferral. We're going to also have a video on what an exchange fund can do, another way you can diversify a position without triggering capital gains. So there are a few other things. This is just one tool in the toolbox. But Trevor, thanks for your time today.
Yeah, you're
Appreciate
welcome,
it.
Matt.
All right.